I mean, I had a gun in my house. That goes without saying. But getting to a range and actually getting involved with shooting sports is a lot harder in LA than it ever was in New Jersey. Now, it's different back east. I used to be able to walk off the back porch into the woods with my shotgun over my shoulder and my New Jersey hunting license on the back of my orange vest. And the neighbors would all say, "Hey, good luck, Chuck. Go, bring us back a squirrel or whatever." Now they call out the SWAT team. Things have changed a lot. But it's been my privilege and pleasure to represent the NRA, the CRPA, firearms owners across the state of California for almost going on 20 years. I say my privilege and pleasure because most lawyers get involved. They go to law school, they have dreams about something they're going to get involved in. The joke is, they go to school because there's a lot of greed and corruption in the world. And by the time they get out of law school, what they want to do is cash in on it. And that's what a lot of lawyers do. I went to school, I got out and prosecuted for a while, and then I went for a big firm, worked for a big firm, because I had big student loans that I had to pay off. And I finally got out of there because I realized, the more I watched other lawyers, that most lawyers, their ideals that they have in law school fall by the wayside as money becomes more and more important. And these days, more and more lawyers are fighting over money issues for businesses, and don't get me wrong, it's part of doing business. But it's really nice to be able to be not just an activist, not just an advocate, but also an activist, to be fighting for something that I really believe in. And I am both an advocate, a legal advocate, and an activist. And it creeps over into my personal life. This is my dog, my chocolate lab. You can tell. His name is Hester.
Can you go by Chuck?
Okay. Now, when my first son was born, my wife thought we were going to name him after a horse. His name is Colton. Of course, I knew better. I knew what we were really naming him after. When my second son came along, I'm thinking, I got a great name for him. Unfortunately, my wife was on to me by then, so she put the kibosh on that, my second son. It was awesome. So I want to talk to you tonight mostly about litigation, because there is right now, and this is not an understatement, there is an epic legal battle going on for the future of the Second Amendment. I think it's the tip of the spear on the battle, the cultural battle going on. And God bless Trump Destin. He was talking about this cultural battle years before we lost him. But it is absolutely going on. You see it with the Obama administration. You see it with the sort of cultural divide. And the Second Amendment is the tip of the spear in that fight for the future of freedom. So there are a number of things that CRPA and NRA do together in the state of California. They do local education and lobbying. We're fighting local ordinances all over the state right now. You may have heard about Sunnyvale and San Francisco passing laws banning the possession of magazines that hold over 10 rounds. We filed lawsuits against San Francisco already. And in typical fashion, they always screw these things up. They're so anxious to get a press, to get their name in the paper and say how bad, how evil the NRA is. When they passed these bans, they didn't exempt police officers. And so we didn't say anything about it until after they finalized the vote. We recruited the veteran, the retired police officers as a plaintiff, and now we've sent our analysis to the active cops in Sunnyvale and San Francisco, and they're all going apoplectic because they're now realizing that the only guns that are exempt are their duty guns. That's just an example of some of the local stuff. We do state legislative council for the NRA and CRPA. Both of those associations have lobbyists in Sacramento working full-time to try and stop bad laws. And you've probably heard about some of the bad laws that we almost got passed this year. Regulatory council, once those laws are passed, we have administrative agencies, executive agencies that try and interpret them to gun owners' disadvantage. They want to want to make them, interpret them as broadly as they can, to prohibit as much as they can. And then there's litigation. And tonight I'm going to focus on litigation. I could do an hour speech on each of these topics about all the things that NRA and CRPA are doing in this state on each of these issues. But tonight is I'm going to focus on litigation because CRPA Foundation, which we're raising money for here tonight, funds a lot of the litigation efforts in California. 501c3 can pay for litigation efforts. They can't pay for lobbying, but they can pay for litigation. And litigation is becoming sort of the another leg on the chair, so to speak, of gun rights advocacy. So first I want to give you a little background about how we got to where we are right now. We're in, as I said, a sort of an epic battle. It started with the National Firearms Act of 1934. Everybody says the NRA never compromised. The NRA helped them write that legislation which banned fully automatic firearms back in 1934. They learned from that mistake because every time we're told, this is all we need, just to pass this law and we won't need anything else to solve all our problems, and that's always a bold-faced lie. In 1939, we got one case out of the United States Supreme Court that was used against us for years, saying that the Second Amendment protected a collective right, not an individual right, a right for a state to have a militia, as opposed to an individual right that each of us have to keep and bear arms. That case dealt with short-barreled shotguns. I could do another speech just on the Miller case because there was no briefing submitted by the lawyer for Miller because he wasn't getting paid. So it was a one-sided case, not particularly surprising when the Supreme Court comes down and says short-barreled shotguns aren't protected by the Second Amendment because they're not commonly used for militia purposes. Probably not true if they'd have submitted some facts even back then. But regardless, it became the focal point of a fight about whether there was a collective or an individual right to keep and bear arms. In 1968, we got the Gun Control Act, and NRA started getting political. And in 1974, we had the NRA Cincinnati Revolt, the board directors revolt, that resulted in, ultimately, the formation of the Institute for Legislative Action. And significantly, the board of directors voted, back then, to take an appropriate case to the United States Supreme Court on the Second Amendment as soon as possible. This is something that's played down. But at the same time, they also began funding and promoting scholarship about the Second Amendment that it got away from the collective rights model and got into the individual rights model. And the more they did, the more they proved that the Second Amendment was always designed to protect the fundamental individual right. Now, unfortunately, I can't get this slide to work because I don't have the two people that would be competent to help me make the technology work. One is an engineer, the other is my 13-year-old. But I hope you've seen this movie. It's Moonstruck with Cher and Nicolas Cage. And Nicolas Cage has just told her that he loves her. And she slaps him across the face and says, snap out of it. That's what I want to say to people who say the NRA and the CRPA don't want to win the Second Amendment fight because they want to keep using it as a fundraising vehicle and justify their lobbying expenses and all this other. It's complete baloney. The Second Amendment right now, because of some of the recent decisions that I'll get to in a second, is the Full Employment Act for Second Amendment, for gun lawyers. Unfortunately, there's a lot of terrible lawyers which think that they can just jump into the Second Amendment fight and file a brief that cites the Heller case or the McDonald case and win on that basis. Obviously, that's not happening. But it's never been a situation where the NRA didn't want to get a case in the Supreme Court and didn't want to win that case. In fact, they spent 30 years trying. And I was personally involved in many of the cases that we tried to get to the Supreme Court from California. One was the Fresno rifle and pistol case that they filed immediately after the 1989, or shortly after the 1989 assault law was passed. One was Hickman versus Block, which was over concealed licenses in Orange County. One was Nordyke v. King. There were others. Nordyke v. King was the gun show ban in Alameda County. We tried to get the Supreme Court to take all of those. The reason the Supreme Court didn't take those cases, we have come to learn, is because our friends on the Supreme Court were voting not to take the case. There is a rule of 4 and a rule of 5 at the United States Supreme Court. The rule of 4 is if 4 justices vote to take a case, the case gets heard. But it takes 5 justices' votes to win a case. So some of the judges on the Supreme Court who knew we didn't have 5 voted not to take the case because they knew we would lose. Now, in 1998, we got a nice development on Second Amendment jurisprudence with the United States versus Emerson case. This was a doctor down in Texas. His wife and he were getting a divorce. She got a restraining order against him. As part of that restraining order, he couldn't possess firearms. Apparently, he didn't get rid of them all. His wife called the police. He was charged with being a prohibited person possessing a firearm. He moved to dismiss the case on the grounds, on Second Amendment grounds. And the judge down there in Texas actually granted the motion to dismiss, says the Second Amendment does protect the fundamental individual right, and so this is unconstitutional prosecution. That was a great result. Now, this was the Clinton administration, and they obviously appealed. And they went to the Court of Appeals in the 5th Circuit. God bless the 5th Circuit. We're in the 9th Circuit. Those are the folks that don't want to say under God and place the flag. And Justice Reinhardt was married to Ramona Ripson, the head of the ACLU, he was one of the head judges there. So we're in a much more hostile environment. The Court of Appeals in the 5th Circuit, when they had that argument, they had what's called a warm bench. Because when the justices got wind of what the claims of the Clinton administration Solicitor General were, they said, "Counsel, are you suggesting that the government could ban the civilian possession of firearms entirely?" And the Clinton administration lawyer said, Solicitor General said, yes, the government could ban civilian possession of firearms entirely. And the one judge on the 3-judge panel looked at the other and said, well, I hate to burst your bubble, counsel, but between me and Judge Jones over here, we own enough guns to arm a small country. That's a warm bench. So they said that the Second Amendment does protect the fundamental individual right. And in 2002, the Supreme Court declined to review that case. Then in 2002, we got the Silveria decision out of the 9th Circuit. Justice Reinhardt wrote it, and it was brought by an ill-advised case challenging the Assault Weapon Control Act brought by an underfunded, unprepared, and not completely competent lawyer who thought that now because Emerson came down, everything was going to change. Well, they got a split of opinion, and Justice Reinhardt took the opportunity to use the Silveria case as an opportunity to completely try and deconstruct the Emerson decision. Well, as a result of that, we got a split of the circuits, and when you get a split of the federal circuits, that's when the Supreme Court starts taking notice. We got a much more pronounced split. There was really sort of a split already. In any event, the Cato Institute in 2002, and a particular lawyer associated with the Cato Institute, saw this opportunity. He wasn't really a gun owner. He wasn't really a gun rights enthusiast. He saw it as an intellectual exercise to resolve a constitutional question. Now, I don't see that as a real good strategy, because what really happens is the libertarian strategy, and don't get me wrong, because I have a lot of libertarian leanings, and the libertarian strategy most lately seems to be, we don't care if it gets worse, we don't care if we lose, because it's going to have to get worse before it gets any better. That's not really, in my view, the way to pursue an expansion of and confirmation of what the Second Amendment is all about. In any event, in 2003, they recruited some plaintiffs and they filed a Heller case against the District of Columbia to challenge the District of Columbia's ban on the possession of handguns in their home without a license, which they hadn't issued in 20 years. And all long guns had to be disassembled and couldn't be reassembled even for self-defense. They lost in the district court. The district court trial judge ruled against the Second Amendment claim. And between the time that they lost in the district court and the time they got it into the Court of Appeals, two very, 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 very significant things happened. Justice Rehnquist died, and there's fairly broad consensus, though some disagreement about whether or not he would have voted for the Second Amendment. By and large, people think he would have voted, legal scholars think he would have voted against an individual rights argument, the Second Amendment. And Justice O'Connor, who there's pretty much universal agreement would have voted against the Second Amendment, had to retire because her husband unexpectedly got Alzheimer's, and she had to take care of him. Now, those weren't predictable, obviously. But because those two judges were on the bench at the time that the Heller case was filed, there was some great reluctance about whether or not to let the Heller case go forward. In 2007, the Court of Appeals, this is before the United States Supreme Court, said that the Second Amendment does protect a fundamental individual right. In 2007, the Supreme Court accepted Heller for review because the District of Columbia, which had lost, asked the Supreme Court to hear it. And in 2008, we got this beautiful Heller decision that says the Second Amendment does protect a fundamental individual right. Went through all the history of the Second Amendment and applied it to the District of Columbia's ordinance, and thankfully we won. But we only won by one vote. We won under the rule of 5, we won by 5. If it hadn't been for O'Connor and Rehnquist losing, we would all be Red Dawn in those re-education camps, learning what this Constitution really means and learning to love Big Brother. That's how close we came to being in that kind of situation. In 2010, almost as an afterthought, but really equally important, the McDonald case came down. It wasn't really tricky to figure out that the incorporation issue was the next issue. If you remember from civics class, and most of you look old enough to have actually taken one in school. I don't think my kids are getting them these days. But the Bill of Rights doesn't apply to the states. It has to be incorporated to the states. The states insisted on the Bill of Rights in order to restrict the federal government. Then the 14th Amendment came along so that the Bill of Rights would apply to freed slaves and incorporated the Bill of Rights against the states, limited states' infringements on those fundamental rights, but it's selectively incorporated, meaning you got to get a case to actually say it's incorporated. So there's been a case that says the First Amendment is incorporated, the Fourth Amendment is incorporated, but there hadn't been a case that said the Second Amendment was incorporated. McDonald came down, and the NRA and the CRPA were both heavily involved as amicus in, CRPA was amicus in Heller McDonald. NRA was actually a party in the McDonald case. There are those who say it wasn't, and that's primarily, I think, based on some fundraising strategies. But the bottom line is, NRA got over $1 million for reimbursement for their attorney's fees that were spent with their lawyers litigating the McDonald case. Those checks, I wish I could pull those up larger because they're from the village of Oak Park and from the city of Chicago. There's nothing quite like getting a check from the city of Chicago. Except maybe getting a check from the city of San Francisco. So since 2008 and 2010 decisions get down, there's been a flurry of litigation across the country. In California, we filed a case against San Francisco over their public housing law. They banned guns in public housing. They caved. They knew that was too close to Heller. They didn't want to litigate that issue, so they revoked their policy that banned guns in public housing rather than get a bad legal precedent. In Jackson, that case is still going on. We're challenging the city of San Francisco's ban against the requirement that you have to have all your guns locked, your handguns locked up in your house at all times, unless you're carrying it. And interestingly enough, they claim that you actually have to either lock it up or carry it on your body while you're sleeping. So you have to have it in a holster on your body over your PJs when you climb into bed. You know, I don't know about you, but with my wife, I'm sleeping in the guest room. And so that case is still being reviewed. And then the Fiscal case really wasn't a Second Amendment case, it was a preemption case, but I'd like to mention it just because I'd like to talk about suing San Francisco. Because I know when I go into that airport and I see that welcome to San Francisco sign and the mayor's smiling face saying, welcome to San Francisco, I know he's talking to us. And then I also want to mention the Parker case, which struck down AB 962, the state law that would have required that you couldn't buy ammunition online and you would have to do a thumbprint and register your purchase of ammunition. We sued against that and prevailed, and just recently got the Court of Appeals confirmed the trial court's opinion and enjoined the enforcement of that law. So that was a gigantic victory. So after Heller and McDonald, though, back to the Second Amendment jurisprudence, do that again. We got a lot of cases trying to argue about the law is trying to condemn either bad, quote unquote, what is bad, obviously that's where we all argue, bad guys, bad guns, and bad places. Those are kind of the rough categories of case that are out there being litigated right now. And the issue, the primary issue that's being litigated is what's the standard of review. I used to say that George Washington called the Second Amendment liberty's teeth. Then I said that at a seminar that Clayton Kramer was at, and he pulls out this research paper that he did on how George Washington wasn't the guy who actually said that. Nobody ever knows who, they can't figure out who exactly said it, so I'm going to take credit for it. Hey, the Second Amendment is liberty's teeth. It's the thing that protects all the other amendments. Charles Heston said something along those lines. But the standard of review determines how many teeth the Second Amendment has. Is it going to be a strong Second Amendment that stops local governments or state governments or federal government from infringing on our rights, or is it going to be some kind of deference to the government? And they always love to talk about public safety, and we've got to save the children, and we've got to do something about gun violence, and something. Of course, they don't say something that works. They just say we got to do something. The degree of constitutional infringement that's going to be tolerated depends on that standard of review, that level of scrutiny. And there are several. There's rational basis. Rational basis basically, if the legislature says the sky is black during the day, it's dark out, so we're going to require everyone to keep their lights on all day long. Even if the court looks out the window and sees the sun outside, it still says, well, the legislature said this, so I'm not going to second guess the legislature. Intermediate scrutiny is someplace in between. Strict scrutiny, there has to be a narrow, compelling governmental interest and a law that's narrowly tailored not to infringe beyond what's absolutely necessary to address that interest. That's your classic First Amendment analysis. So you can require somebody to speak in a certain place, but you can't ban them from speaking at all. You can put time, place, and manner restrictions on speech, but you can't ban. We're fighting now over that standard of review. And it's going to be decided by the United States Supreme Court. There's something, another case is going to get before the Supreme Court, if not this session, probably next session. If it doesn't happen, it means the Supreme Court doesn't want to revisit this issue, and we're going to be stuck with what is evolving and coming out of the courts right now, which is a watered-down Second Amendment, which really doesn't have much in the way of teeth at all. We've got an intermediate scrutiny test being applied by most federal circuit courts of appeal, and it really doesn't do much to strike down laws. It gives great deference to the government's findings, their justification for the law. So which one of these cases is going to get in front of the Supreme Court, and how well financed is it going to be when it gets there, is the big question. Probably the most likely case that the Supreme Court might still take this year was the NRA versus McGraw case, which is the 18 to 21-year-old ban on 18 to 21-year-olds from buying guns from a gun dealer. They can buy them at gun shows or private party, but they can't buy them from an FFL. That was filed in Texas, and the Supreme Court has been asked to hear it, and it still hasn't decided. It's rejected a lot of cases, hasn't accepted a lot of cases for review, but in every case that asked to be reviewed, the Supreme Court has done something very unusual. It's actually asked the opposing counsel to say why it should take the case. Ordinarily, Second Amendment Supreme Court practitioners know when you ask the Supreme Court to take a case, they review 99 out of 100 cases just perfunctorily, without any reasoning or anything. They just don't take the case. And so the opposing counsel, the one that wants the court to not take the case, typically knows better than to file any kind of a brief saying don't take the case, because all you really do is raise the profile of the case, and ironically, you can increase the likelihood that the Supreme Court would take the case. So with Second Amendment cases that the Supreme Court's been asked to review, the Supreme Court's actually been ordering the opposing counsel to file that brief about why they shouldn't take the case. That shows a level of interest that they are not displaying by and large with all the other cases. So it shows that they have some interest. And also Sotomayor and Justice Scalia have come out and said, right after Sandy Hook, when there was all these new laws being passed in Connecticut, New York, and Colorado, that it's pretty inevitable that the Supreme Court is going to have to take a Second Amendment case soon. What they say the standard of review is going to determine whether or not we have a Supreme Court, we have a Second Amendment that means anything, a Second Amendment that really protects our right or not. There are several cases still pending, CRPA NRA cases that are still pending in the Ninth Circuit, Peruta, Richards, McKay. Any of those can come down any day. So we're waiting on those, and they will all be appealable. Ironically, the Sunnydale and San Francisco bans on the possession of magazines that hold over 10 rounds may create sort of a rocket docket, a expedited route to the Supreme Court, because we'll be seeking injunctive relief. It's a shortened time period, and it could go straight from the District Court to the Ninth Circuit to the Supreme Court, conceivably in 3, 4, 5, 6 months, as opposed to 3, 4, 5 years. So you should be watching those cases, because they may be the ones that become the vehicle for the Supreme Court to clarify exactly how strong the Second Amendment is. As a little off topic from litigation here now, if you watch the news, you're probably picking up on this campaign of shame, which is being launched against gun owners. I've got on my website the most recent PR Bible that the gun ban lobby has come out with about how to change people's minds, how to basically appeal to people's emotions with sympathy stories, and then hoodwink them into buying into gun control arguments because they're emotionally attached. It's basically a play-by-play for how to try and convince people to support gun control. In fact, Mayor Bloomberg, who has pledged to put $800 million and is well on his way towards putting that much money into the fight against the Second Amendment, to give us a Second Amendment, has sent something out telling people at Thanksgiving, so this is going to make for interesting tables at the houses you visit if anybody brings this up. They're trying to tell people on Thanksgiving, talk to your family about why it's appropriate to have gun control. Boy, I hope somebody tries that in my house. But they're adopting the tobacco law. Bloomberg has, like I said, $800 million pledged to this, plus 50 lawyers on his staff full-time on Mayors Against Illegal Guns, working on gun control issues, plus another 100 or so that he's gotten hired by cities across the country to work on these issues in local cities. So it is a well-financed, well-coordinated, and very clever group of lawyers who are coming up with very clever arguments, including PR arguments, to try and advance gun control and gun bans and try and get a case, try and stop. Right now, they don't really want a case to get to the Supreme Court because we still probably have that 5. But everybody should say a little extra prayer for Justice Scalia, because God forbid he or one of the 5 gets hit by a bus, we're going to be back in that red dawn education camp. A couple other things that you should all be aware of were the legislative proposals that they're coming up with kind of turn the tables on gun owners. They're trying to make us feel guilty and make people make us feel guilty. They're making it difficult to actually cooperate with police, because the 48-hour theft reporting laws that are starting to take hold locally, we got them killed in Sacramento, thankfully. But if you think about it, if you get a gun stolen from you, and I don't go check my gun safe every minute. Nobody does. I mean, I fondle my guns occasionally, but they expect you to know where those guns are every minute of every day. And if one is missing for a minute, you should have known it was missing. And if you don't report it by the time within 48 hours of when you should have known, you're a criminal. So when a police officer calls you and says your gun turned up at a crime scene, how did it get there? Who might have stolen it from your house? You have to lawyer up before you can cooperate with the police. The APS program, the Arms Prohibited Persons System program, is going out to ostensibly seize guns from, in Kamala Harris's words, violent felons and people who have been adjudicated mentally ill by a court. Well, that's completely untrue. The people in the database the prohibited persons database, most people don't realize they're prohibited. There's 40 ways that you can become prohibited, and the vast majority of people are never told that they're prohibited if they do some kind of plea bargain for a misdemeanor plea. A lot of people they plead to a felony like drug possession. They get cleaned up, they reduce it to a misdemeanor, but they're never told, or they never don't realize that the paperwork wasn't done right, so they're still prohibited. There's all kinds of mistakes in the system. In fact, it's off by up to 30%. So this is another risk that is now becoming a part of gun ownership, and it's unfortunately there's a chill being put on the relationship that gun owners, law-abiding gun owners, we ordinarily have with police. We want to cooperate, we want to help them solve crimes. But now part of the campaign machine is to try and make you feel like, and make other people think you might be a criminal. I passed out some brochures with some goodies in them. There's some warnings, know your rights. When you're talking to a police officer, keep police out of your gun safe. My book is available on the website. Second edition is coming out in January. But think of it as a magazine subscription. Given the way Sacramento is, there's probably going to be a new edition every year. So please go there. If you didn't get one of those brochures, go to the website. You can order these materials there. They're all free. And please give generously to the CRPA. I reduced my rates dramatically for the NRA and the CRPA, but I can't work for free. My wife won't let me. And there's a lot of other people in my office, all of whom are on the team. There's a national team of attorneys that I work with every day in Washington, D.C., and Virginia. The NRA has the best team of lawyers on these cases that they could possibly field, including Paul Clement, the former Solicitor General, one of the most respected Second Amendment litigators that there is. But it still costs money. And we need, we're going up against Bloomberg and $600 million. So please give generously.